Hello. Today we will explain the common ways to hold real estate titles ownership in California. For various entities, including sole proprietors, married spouses, domestic partners, partnerships, and trust holders. Form of ownership, division of interests, title of ownership, rights of possession, requirements upon transfer, disposition upon death. It deals with the status of successors, rights of creditors, etc. For example, joint property rights are between spouses or civil partners. Right of survivorship in joint property can be established between spouses or civil partners. In the form of joint tenancy, tenancy in common, partnership, ownership, right of trust, etc. Ownership can be established, and distribution of profits, title of ownership, right of possession, etc. The method of transfer, how it is handled upon death, the status of successors, the rights of creditors, etc. are different. It is not intended to provide legal advice and is not intended to determine the most advantageous form of ownership for your particular situation. You should consult an attorney or accountant for a specific explanation of the definitions, characteristics, and legal implications of each form of ownership. This is because it is an illegal legal practice for a non-lawyer to give personal advice on how to hold title. Therefore, only the common methods of holding real estate titles are covered below. 1. Sole ownership discretion, only one person holds ownership. Example, John Doe, single. Conveyance, only the sole owner can convey the property. Death, upon the owner's death, ownership is transferred according to a will or legal inheritance process. Successor's status, the legal heir inherits ownership. Creditor's rights, property can be disposed of by a creditor for the owner's debt. Presumption, presumed to be privately owned. 2. Community property ownership discretion applies to married couples or registered domestic partners. All property acquired during a marriage or registered partnership is considered community property unless specifically designated. Each spouse or partner owns an undivided half interest. Example, John Doe and Jane Doe, joint property as husband and wife. Conveyance, both spouses or registered partners must transfer together. Death, the deceased spouse partners a half share is transferred through the inheritance process. Successor's status, a will or legal inheritance procedure creates joint property rights between the heir and the surviving spouse or partner. Creditor's rights, community property is liable for the debts of a spouse or partner. Presumption, property acquired during a marriage or partnership is considered community property.
3. Community property with right of survivorship. Title description, similar to community property, but with the added benefit of right of survivorship. When one spouse or partner dies, the entire estate automatically passes to the surviving spouse or partner. Example, John Doe and Jane Doe, husband and wife as joint property rights with right of survival. Transfer, death, successor status, creditor rights, and presumption information are similar to community property rights. But upon death, the entire estate automatically passes to the surviving spouse or partner. 4. Joint tenancy with right of survivorship. Ownership description, two or more people own property together in equal shares. Right of survivorship applies, so that when one owner dies, their interest automatically passes to the surviving owners. Example, John Doe and Jane Doe, joint owners as joint tenants with right of survivorship. Conveyance, conveyance by one co-owner may dissolve a joint tenancy relationship. Death, a deceased owner's interest automatically passes to the surviving co-owners. Successor status, the last survivor owns the entire interest. Creditor's rights, a co-owner's share may be sold by a creditor. Presumption, must be explicitly designated as joint tenancy. 5. Tenants in common. Ownership discretion, two or more people own property together, but the percentage of ownership may be unequal. There is no right to survive. When one owner dies, their interest is transferred according to their will, or, if there is no will, according to inheritance laws. Example, John Doe has a 50% undivided share, and Hong Gil Soon has a 50% undivided share. Conveyance. Each co-owner can convey his or her share independently. Death. A deceased owner's interest is transferred by will or inheritance law. Successor's status. The heirs or legal heirs from a joint tenancy relationship. Creditor's rights. Each co-owner's share may be sold by that owner's creditors. Presumption. Joint tenancy is considered unless otherwise specified. 6. Partnership holding title. A general partnership may hold real estate titles. Ownership rights and profit distribution are determined by the partnership agreement. Basically, there is no right of survivorship, and the deceased partner's interests are distributed according to the partnership agreement or state law. Example, John Doe and Jane Doe, co-owners as a general partnership. Conveyance, determined by partnership agreement. Death. A deceased partner's interest is distributed according to the partnership agreement or state law. Successor's status, defined by partnership agreement or state law. Creditor's rights. Property owned by the partnership has creditors' rights for partnership debts. Presumption, expressly owned by a partnership.
7. Trust holding title. Legal title to the property is held by the trustee for the benefit of the beneficiaries named in the trust agreement. The trust agreement determines how the property will be managed, used, and ultimately distributed. Example, as trustee of the John Doe and John Doe Family Life Trust, for the benefit of John Doe, Hong Gil Soon and their children. Conveyance, the trustee may convey property pursuant to the trust agreement. Death, a trust agreement usually provides for distribution upon the death of the settlor. Successor's status, a trust agreement typically specifies distributions after the grantor's death. Creditor's rights. Generally, creditors cannot enforce against the beneficiary's interest. Presumption, a trust is expressly created by an executed trust agreement. Holding a title through a trust can be useful for certain estate management and distribution purposes, and it is important to obtain legal advice. All of the above information is provided for informational purposes only, and decisions should be made taking into account the legal consequences of how ownership is held. We recommend that you consult with a qualified real estate attorney and/or accountant to determine the most advantageous form of ownership in your particular situation. No one other than a lawyer can give you advice on how to hold title. This is because doing so would constitute an illegal legal practice. Additionally, this information may vary from state to state. I hope the above general information has been useful to you. Thank you for watching.